Well, kia ora koutou katoa. It's really good to be here again. Thank you for that kind introduction. So I am Duncan Webb. I'm the Member of Parliament for Christchurch Central, but really here more in my role as the Opposition Justice spokesperson. And having come out of a pretty bruising election, if you remember, we lost. One of the real struggles for me was the discussion around crime and justice. So that's what I want to address today. First thing I want to do is want to recognise that there are real concerns around what's happening in our community around crime and justice, and certainly headlining a lot of the time was youth justice and the ram raids. And I guess in terms of trying to squeeze what I'm going to say into the topic I've been given, which is always a challenge, it's really difficult to, in a heated political arena, think carefully about things like criminal gangs, youth offending and ram raids and so on, when the evidence says one thing, but the political rhetoric says another. So that's a real challenge for us. And I guess having come out of the election, the Labour Party and me and my colleagues had to really reflect and say, well, what went so badly wrong? And I think one of the things, to just kind of put context around the thinking that I'm now doing, is we were so focused on the evidence, we failed to satisfactorily address essentially the fear and concern in the community. Because it's no good telling people it's not as bad as you think it is, when, because of media and political rhetoric, they actually think it's terrible and they're at real risk. So that's a real challenge for us, is to recognise that it's not enough for communities to be safe, they have to actually feel safe. And so today what I want to do is I want to kind of take a big step back from all of the kind of hurly-burly of that political rhetoric and crackdown on crime and consequences for offending and things like that, and just ask the question, when we come to address the criminal justice system, what do we actually, what is the object? What is the purpose? What is it for? Because we often take a knee-jerk reaction to it. And I think that some of the answers to that question, and there are a number of levels to it, some of the answers are a little awkward to confront, right? That what we actually want. So that's what I want to do today, and I do want to make it really clear. And I know we've got some people who are knowledgeable in this area who've previously spoken here on this, but I do want to make it clear that this is a work in progress, because in terms of my job as an opposition spokesperson, I have got to put a proposition in the criminal justice sphere to say, what we've got now can be improved in the following ways. And the first thing to do that, in any policy question is, well, what's the outcome we want? What are we actually aiming for? So if we think about criminal justice in general, and it's really important to say the criminal justice system isn't just the criminal law, or the prisons, or the police force. It's the whole ecosystem of it. And that's one of the challenges of thinking about criminal justice, because it's all very nice to do things like impose a gang patch ban. That's kind of right. That's one of the current discussions. Let's ban gang patches. Let's make it a criminal offence. This is one of the pieces of work we're doing in Parliament at the moment, to wear a gang patch. Now, Laws 101 is making it a crime to wear a gang patch does not mean gang patches disappear. There's a whole lot more that has to happen before gang patches disappear, including the police having the resources to address it, the courts taking whatever approach they need to take, the correction system taking a certain approach as well, and ultimately there being some kind of social consensus that gang patches need to disappear. Whether that happens or not, we are going to get this gang patch ban, is yet to be seen. But if we come back, the usual response and the kind of headline statement about the criminal justice system is often, particularly in the political arena, that we want communities to be safe. That's the usual kind of headline. Community safety is what it's all about. And that's a good kind of broad objective. One of the questions we then ask is, okay, well, if that's kind of a broad objective, what's the evidence between the intervention we're taking and community safety in the long run, And one of the interesting things is that if we look at community safety around the world, countries that take a pathway similar to the one we're currently on are generally unsafe countries, and countries that take a different path are in general safer than we are. And there's plenty of statistics out there, and I could provide you all with a reading list a bit later on for that. But I think it's more than that, isn't it? Because I think I just want to, again, dig a little bit deeper into what the real purpose is. Because if we think about the criminal justice system and the wider system of rules and laws we have, there's a little bit about shaping the community we want to have. You can put it in a kind of Orwellian way and say it's a bit about social control. But the criminal law does, and always has, what's essentially a moral and social element. It fundamentally says what is permitted behaviour and what is prohibited behaviour. And whilst some of it is blindingly obvious, burglary, assault, sexual offending, there's a whole range of conduct which is much less obvious. So, rules around disorderly conduct. What comprises disorderly conduct? There was a flag burning incident some years ago that raised a lot of concerns. Is it permitted or prohibited? And if we think of the kind of trend in the law since the 1960s and 70s, it's been away from kind of what might be called victimless crimes or moralist interventions towards crimes which have a real social impact. So we saw prostitution decriminalised. We've seen cannabis less criminalised. Homosexual law reform. But those crimes were all about the kind of society we thought was morally acceptable as well. And we've got to remember that is part of what the criminal law does. And so if I come back and think about the gang patch ban, it's quite interesting. There's a real question here. Why are we banning gang patches? And we need to think carefully about that, because gang patches in and of themselves cause no harm, right? And one of the challenges with that, and I've got to disclose, I acted for the Hells Angels in Wanganui when they had their gang patches banned there, and ran a free speech argument that people are allowed to express themselves, including show their affiliations to certain organisations, like gangs. And that was successful. One of the challenges is that gangs are bad. Let's be really upfront about that. I talked to Jared Gilbert yesterday, gang expert, and he's very clear as well. Gangs are not good organisations. There might be little threads in there that have some social benefit, but by and large, they are organisations whose very kind of ethos is violence, criminal offending, and living outside of the law. So they're bad things. So they're very easy targets for encroachment on basic rights. So we've got the encroachment on free speech, banning gang patches. And the other one that this law is going to do is encroachment on the right to meet and assemble. So the police are going to have powers to disperse groups of gang members who are acting in an unruly way, right? Who are being disruptive of the local community. What does that exactly mean? And I guess it's always a concern when we give powers to the police which are not clear. Because and it's not even that they have to be a gang member, they just have to be suspected of being a gang member. And being disruptive of the community, what does that mean? If they're at the park legally, having a few beers legally, and playing some bad rap music, is that disruptive? There's a real danger that some of the community look at these people who don't look like them, they don't live like them, they don't listen to the same music that they listen to, and they feel uncomfortable, right? Is that disruptive? We've got to be really cautious about, because people are so different and live a life we don't approve of, and in fact may indeed be associated with a criminal organisation, that just by dint of that we say you don't get the same protections of the law that we do. But I digress a little bit. That's my kind of wider point, is that the law is about creating a community that we agree is the community we want to live in, within bounds, right? It sets baselines. It doesn't set aspirational goals. The law doesn't really have the job, by and large, of setting, this is the kind of aspirational community we want to be in. Let's do that here, right? But it does say we won't accept that kind of behaviour. The criminal law does more than that. It sort of sets out and says, and this behaviour in particular we find as reprehensible. As a community, we don't just, it's not just about the shape of it, but assaults, burglary, theft, all of those things that we know are crimes, we denounce them. We say that they're wrong, and if people embark on that course of conduct, we will take action against that person. And it's really important to make the distinction that it's not just like a civil claim. It's not just me who's been punched in the nose taking an action. The Crown, the people, to use the United States framing, takes action against the wrongdoer. So, that's one aspect of it. Excuse me. The other aspect, the other purpose, and this is really a really tricky one, and a lot of this is in the Sentencing Act, says that, look, one of the jobs of the criminal law is to deter. And if you want to, I don't recommend it, it's a little traumatic, but if you want to go on Paul Goldsmith's Facebook account, you can see him talking about cracking down on crime and having tougher sentences. In fact, the National Party policy document going into the election was called Real Consequences for Crime. Now, underlying that is this concept of deterrence, that if we have real consequences for crime, people won't commit crime. And this is the tougher sentencing approach. And there's a whole raft of reforms coming which will reduce the discretion of judges and require people to have tougher sentences, be imprisoned more commonly, and be imprisoned for a longer period of time. The evidential question is this: what is the causal link between tougher sentences and less offending? I mean, that's the evidential question. And we actually know there's two separate parts of it. One is slightly part of another point. But first of all, there's no strong causal link between tougher sentences and lower offending. Criminal offenders, like the gang members we've been talking about, do not hold in their mind what the Crimes Act sentence is and what the judge's discretion is before they engage in criminal conduct. They simply don't. And even the narrative that might be in the newspapers. 3 strikes is the best example. So the 3 strikes regime, which National Act put in place, and we removed, and which they're now putting back, is a criminal regime which says if you have committed 3 serious offences, on your 3rd offence, you will get the maximum penalty that's set out in law. So if it's, one of the famous cases was an indecent assault, maximum penalty 7 years inside. The indecent assault in question in the Fitzgerald case was kissing someone in the street. 7 years imprisonment was the sentence originally handed down in that case. Now, the 3 strikes regime has been looked at both in New Zealand and overseas. And there is no statistically reliable link between changes in offender behaviour and the imposition of 3 strikes regime. So, in a nutshell, deterrence doesn't work, right? Now, that's deterrence overall. There is a kind of another kind of deterrence, which is when an offender comes to court and the judge imposes a sentence and says, well, look, I'm going to give you home detention, but you need to know that you've got to change your ways or else you'll be in jail for a very long period of time. That's an individual deterrence, and certainly offender behaviour can be affected. How much is a really good question, by the kind of sentences imposed and what goes on within the corrections system. And I guess the other point in terms of what longer sentences do towards lowering offending is if you put enough people in prison, they're not in the community, right? So they don't offend. And certainly there is a small group of offenders who essentially are they're broken people who will always offend. It's a tragic truth. I mean, we have a system called preventive detention for people. They will be in prison as long as they pose a risk to society. One of the real challenges for for someone like me who wants an evidence-based system is that if you put enough people away in a short period of time, you will get a drop in crime. But you've also got to look at the long-term impacts. Politics is terrible for long-term planning because we can't see past 3 years. Well, we can, but it's a real challenge to make good decisions across party lines because every 3 years we have a legislated fight over what we do next, and we have these kinds of discussions. So yes, if we have a rising prison population, and we have a very significantly rising prison population at the moment, people who have a propensity for crime will be incarcerated. We will see likely a drop-off in crime rates. At the same time, their children will be without a parent. The jobs that they had will be lost. They will be put in contact with a very robust criminal network in prison, and they will learn the ropes, if they didn't know them already, very well. And when they do leave prison, and they generally do, in not a huge period of time, they will return to their old ways. And in the long term, it's really well established, in the long term, crime rates are driven up by high imprisonment rates. Peter Gluckman, who was the chief science advisor for the National Party, did a great paper on, the evidence-based approach to criminal justice, and he was very clear that imprisonment broke social connections, broke employability, and socialised people towards more criminal offending and networked them into criminal networks. That's the effect that prison has. So, yes, there is a role for community safety taking some offenders out of the community, but we've got to be really cautious about what our prisons are and what they do. Here's the quote from Peter Gluckman. "Prisons are extremely expensive training grounds for further offending, building offenders' criminal careers by teaching them criminal skills, damaging their employment, accommodation and family prospects, and compounding mental health and substance abuse issues." And I think it's worth, just on that final note, just recognising that people who find themselves at that end of the criminal justice system are highly likely to have mental health issues, be neurodivergent, have fetal alcohol syndrome, suffer from alcohol or drug addictions, and so on. And one of the challenges that I have in Parliament in kind of scrutinising what goes on is the lack of capacity of the correction system across the board to address those things. They make some attempts to it, but at the end of the day, the correction system is so stretched for resources that they can barely meet their legal minimum standards of making sure prisoners have exercise, making sure they have humane conditions, making sure they have visitors. The kind of non-statutory aspirational targets, having a rehabilitation plan, addressing alcohol and drug addiction issues, having effective reintegration. They do some of that work, but I've got to say, a lot of it falls by the wayside. And that's really problematic. So what then? There's some of the objects of the criminal justice system that have kind of differing degrees of effectiveness. I want to touch on one that we kind of shy away from, and certainly in the Sentencing Act and in some of the narrative you hear in politics, it's called holding the offender accountable. Right? It's kind of, if you think about that, I mean, you'd never say that to your child, right? If you think of a child doing something wrong and say, right, I'm going to take the step to hold you accountable, right? It's kind of very euphemistic. It means punish, doesn't it? Or retribution. Or in fact, in this place, you might use an Old Testament term and say it's vengeance. And I think it's really important to front up to this, right? Because it actually underpins much of the narrative that we see, and not shy away from it as utterly wrong, but recognise that it's an important component of why we react the way we do to criminal offending. And if we think of some of the really horrible offending we see, recently there was a terrible attack in South Auckland, Papatoetoe, when a shop owner was attacked with a hammer. Terrible attack. Now, the response is essentially that sense of outrage in the community and the desire for retribution. Now, I think there is actually a place for that, but to ensure that we balance it appropriately, I think the first thing we've got to do is recognise it and not call it something like holding the offender accountable, but recognise that the community demands a degree of retribution, that there's kind of this reciprocity, that there's been this community and social harm caused, and essentially we want to make that person's life worse because they're not going to get off scot-free. Now, that's actually quite a difficult conversation to have, because we like to think of ourselves as compassionate and so on and so forth. And in fact, that was the ongoing criticism of the Labour Party's justice policy, soft on crime. That was the constant refrain. The fact that we lowered the prison population across 6 years from a little over 10,000 to around 7,000 people. But made it look like we were opening the doors and letting out these violent offenders because we're soft. The fact of the matter is that every one of those people who was let out of prison was let out on the basis of the law, not on the basis of some change of policy. A lot of the people who were let out were assisted to make parole applications because they didn't have the literacy skills to do it themselves, so someone sat next to them and talked them through it. That's how they got out. But anyway, I think in terms of that kind of hold offenders accountable vengeance point, I think we need to kind of recognise a relatively, a kind of visceral reaction that we have to offending, and that's a genuine consideration in sentencing. And if we do that, then we can kind of balance it. Right? We can say, okay, well, this is a particularly heinous offence, and so that element is going to be given perhaps greater weight than something which we don't have the same community expectation of, retribution, if you like. I guess the other thing that I haven't mentioned yet, and it's something which I think we need to be much more serious about, and that is the rights and position of the victims in all of this. Lawyers are terrible at being kind of obsessed with themselves and their own processes. You go to court, there's a judge up there, the other lawyers over there, and that's the kind of triangle of conflict and resolution that you have. And you sort of forget that there's a victim back there and an offender over there. And we still, there's been significant improvements in how we respond to victims. We've got a Victims' Rights Act, we have a Victims' Impact Statement, we have a Victims' Support Network, as well as, ACC and a whole lot of other government networks which will assist victims. But certainly if you think of a criminal trial or a criminal proceeding, the victims still sit off to one side. They're often a witness, and we've made progress in how we manage witnesses in terms of the trauma of giving evidence as well, but it's still difficult. And so I think one of the questions, or one of the kind of things I want to work through as I kind of develop a policy for hopefully the next Labour government is how we can do better for victims. And I was talking to Judge Saunders before about the fact that the trial process itself is extremely frustrating for victims simply because it takes so long. The idea that you've been victimised and the kind of recognition of the harm that was caused to you doesn't happen for 12, 24, 36 months is actually dismissive of your position. So we need to work better on that. I mean, this is heresy, but we are obsessed in the law with getting things right. And quite often you'll hear that, I mean, if there's appeals, the criminal justice process can take many years. And that's really problematic for victims, is all I think I can say. There's also, and I know you're going to get a talk on this as well, the whole idea of the criminal justice process, and I've referred to it kind of repairing the harm. So there's been and I think we need to be cautious about when we use this, but the whole idea of restorative justice is one which has grown over time. And there is certainly some offending, I think, where we could take a much better approach. One of the things I want to do in the next few months is to go to some of the courts in the North Island, the Rangatahi courts, and the community justice panels, where the communities, the judge sort of says, well, this is not serious offending, so I'm going to send you to a community justice panel, and the communities, essentially the aunties come round, and they sort of can have a talk to the offender and talk with the victim, sometimes at the same time, in other cases in separate meetings, but talk about how amends can be made. And the idea of the aunties or uncles giving the offender a jolly good dressing down, not some judge who is entirely from a different world, but someone who lives down the road, giving them a good dressing down and saying, you've got to sort yourself out, and here's what we think you should do. It's a little more formal than that. There's going to be often anger management courses or drug and alcohol courses or whatever as well. But there's something about a process which says, let's work out in context and on a case-by-case basis how we can mend this tear. And I guess the good thing about those processes is that these might be young people, it might be their first interaction on the wrong side of the law. Now, if it can be resolved in the community in a way which is both supportive in a sense, but if you know what I mean, still pretty confrontational, not easy, then maybe we're diverting that person from a pathway. You know, I think our courts are getting better and better at recognising that many offenders' path is clear if there's not some significant intervention. You know, because it's very much, and this is a tragic thing, it's very much a conveyor belt, right? And one of the challenges is that we know what the drivers are. If we've had a child who's been in care, a child who has mental health issues, a child who's not well nourished, a child who doesn't attend school, a child whose parent is in prison, they're all really strong predictors that that young person will fall into the wrong crowd and get on that, what I've called a conveyor belt of crime. And as I said, I met Jared Gilbert. He said to me, he's got a certain turn of phrase. He said, sometimes it's not. I'm not amazed that people have lives of crime. I'm amazed at the ones that don't. You know, and I think there is a real place, and this is the intersection. And one of the problems in government is this is the intersection of criminal justice with absolutely everything else: housing, health, education. One of the challenges is identifying those both communities but also individuals and saying, well, if we can intervene there and strengthen that community or address the shortcomings in that family, that's really intensive, really expensive, really resource intensive in terms of people, but you know, the long-term benefits of getting that person off the conveyor belt is huge. The political challenge is that investment pays off in 15 or 20 years, right? And I think I think we've made some progress across party lines to do that. We called it the well-being approach. The National Party calls it social investment. It's not quite the same, but there's some crossover. And I think sometimes we're so obsessed with, you know, our politics that we don't actually put our finger on the fact that there is some consensus on some things. Another good example of that, although it's not that early intervention stage, is the alcohol and drug courts, which were established there was a pilot run by the national government, I think, quite some time ago now, it might have been 2012, and then in 2017 the Labour government picked it up and rolled it out further, and these are courts which take people clearly whose offending is driven by substance abuse and offending at a certain level. It's still serious offending, but not very serious offending, and then put them on a pathway to address their alcohol abuse, but also, and this is the really important thing, address things like employability, housing insecurity, literacy, ability to drive. You know, so they have people alongside them who think, okay, if you're going to get onto a pathway of a life within society rather than without, here are all the things we need to address. And I've sat in the alcohol and drug court, and it's a very interesting place. You wouldn't recognise it as a court, but for the building that you're in. I mean, the judge with the court that I was in, the judge asked a offender how long they had been sober for, and I think the number was something like 40 something days, and the court broke out in applause. Now that's pretty unusual in court. And it's an entirely different, and you know, the judge at one point when someone had made a particular achievement got around from her desk and went over and shook the defendant's hand. Now that kind of supportive environment is pretty foreign to most court places. So anyway, so that's the concept of. I started really out talking about restorative justice, and that's the concept of mending what the harm that's caused. And I just checking my time. So look, I do think there's a lot of work to be done in the criminal justice sector, and I don't think we've yet got the answers. I do think running through and kind of having a discussion with the community about why, what we actually want out of our criminal justice system, and really having a discussion around what is the pathway to achieve that. But the real political challenge is to bring people along with a conversation which is that it's a long-term project and not a short-term one. To really think carefully about the relationship between our corrections system and a safe community, because my view is that particularly the prison system, the correction system includes community work and probation and so on, but particularly the prison system does more harm than good. And whilst we will always need it, we need a really careful consideration about how we address it and shape it in a way where people don't come out worse than when they went in, because that's what's happening at the moment. I'd also think we need a conversation about, the way we're framing the law in terms of criminal offending and who is an offender, because I think we need to recognise that one of the things that the criminal law does is it marks people out. It essentially puts a mark on them and says, you're not one of us. And as soon as someone is rejected by a community, there's a real danger that they give up on being part of that community. And that's why things like diversion are so important, to say, look, yes, you're in trouble, but we don't want to mark you out as being a criminal. Here's another pathway, sort yourself out. So it's a long conversation, and it's not an easy one. And one of the challenges for me is that it's not headline grabbing. It hasn't got a great byline.